Today's discussion is between Anna Stanič and Tim Lestrange about geopolitics and energy and resources projects dealing with dispute resolution, dispute triggers and alternative approaches to resolution. Each of Tim and Anna have come from different perspectives and bring a wealth of experience to this field. Anna is based in London, but is an Australian, of course, and a member of the ICC steering committee here. She has been advising for over 25 years on matters of energy law, EU law, and international law with specific emphasis on dispute resolution. She's both been appointed as an arbitrator and acted in arbitrations over that course of time in ICC, LCIA, AAA, and SCC arbitrations with respect to contractual civil law disputes as well. She's a member of the Permanent Court of Arbitration, Court of Arbitrators, and has been since 2019, and is listed in the top 5 of UK power and renewables lawyers and the top UK 15 oil and gas lawyers in chambers and partners for next year and previously in 2023, and a leading practitioner in other areas. So Tim and Anna is based in London. Tim is based in Sydney, but has had a very wide and varied career as well. He's a fellow of the Chartered Institute and a Centre for Effective Dispute Resolution mediator. He's a former managing partner of one of Australia's large law firms, Allens Linklaters, and a former partner of Jones Day. He was general counsel and then a managing director in Europe of the ANZ Bank for over 12 years. He's represented companies, boards, individuals in some of Australia's highest profile domestic and cross-border corporate legal disputes, including the Bell litigation in the Western Australian Supreme Court that went for 20 years, and pursuing Christopher Skase, another 1980s colourful figure. He now is an independent arbitrator with me in Newman's in London and a mediator, and forming expert determinations. So what we're going to do is Anna and Tim are going to interview each other and have a discussion on the topic, and we invite audience participation. We've got a small audience, so if you want to sort of ask questions or things on the way through, I think we're happy for you to be interactive with us. So by all means, feel free to chime in. I'll try and control you if you get naughty. So over to you. I think, Tim, you're going to kick it off, are you?
Sure. And thank you, everyone, for joining us here today, this busy time of year, particularly. So thank you, Stephen, for introducing us so generously, and for Anna and I joining us here. So I thought I'd just a great opportunity, because Anna's in town in Sydney, just to hear from Anna about the world of energy and disputes, the transitioning to renewables, the stresses and strains that's creating on the corporate community that we know, whether it's in Australia or the Middle East or Europe, and the disputes that they're arising. And one of the things I'd like to kick it off with is, in the context of those disputes, which often are multi-party with lots of different interests in it, what are you seeing? What are the thematics that you're seeing in Europe at the moment? And then the part 2 of that question is, how well are the traditional forms of dispute resolution like arbitration and court process, how are they handling this multifaceted, the tensions that are there with governments wanting higher royalties, inflationary forces, cost pressures, etc. People need to recut and redo deals, and yet you've got the sort of formal process of arbitration. But so your perspective on the first, what are you seeing out there in Europe?
Okay, well, in Europe, in addition to the energy transition disputes that are many, including whether they're commercial disputes triggered by energy transition or investment treaty disputes triggered by phase out in the case of RWE and Uniper cases, coal, the ExxonMobil case that was filed against the Netherlands with respect to sort of stopping of the gas field, Groningen gas field, which is directly related to the Netherlands' obligation to reduce CO2 emissions. So we're seeing all of those kind of claims, and I'll talk about a bit more about those in a moment. But we're also seeing claims triggered by war, the invasion of Russia, by Russia of the Ukraine, and the sanctions and countermeasures to the sanctions that have triggered a huge amount of disputes. And so we're seeing geopolitics very much now in Europe playing an important role. And as you asked the second question, I might just highlight that is, there is the fact that we're experiencing now is that arbitration is being weaponized as a tool of war now. And so we can talk about it more about where clients are going in terms of dealing with the situation, where arbitration is part of, or the inability to use arbitration as a result of it being weaponized by sanctions. And here I mean the European Union in particular, effectively barring any claims by sanctioned parties, and also in response to that by non-sanctioned parties that have entered into contracts with sanctioned parties. So you have a whole load of contracts that are simply immobilized. And then you have countermeasures imposed by the Russians, for example, to invalidate arbitration agreements, since if you pursue an arbitration with respect to a sanctioned contract, you are not going to get anywhere, even because of the fact that in most jurisdictions, and I'll give the example here of the English court, which has effectively deemed sanctions a force majeure event by effectively in the recent Supreme Court decision of RTI versus Mer Shipping, saying that the designation of a Russian company as a sanctioned entity and therefore the inability to pay in US dollars was a force majeure event in itself, even though you had a reasonable endeavors obligation, which you would have thought would oblige them to accept payment in from US dollars into euros. But the court basically said, no, that's outside the four corners of the contract. And so since you can't make payments in US dollars, this is a force majeure event. So we have sanctions effectively even though they're unilateral sanctions, so they're not sanctions that are mandatorily given effect by, for example, English law, for that matter, Australian law, but they come through the back door and effectively prevent contracts even being, to find alternatives to overcome sanctions. And that leads to what you were already alluding to, and that is that actually companies really want to get on with business. They want to be in a position to recover, particularly in large energy contracts, advanced payments, performance bonds, or whatever it is that were paid as a result of these contracts before these contracts became sanctioned, and they're not able to find a way to do it. And so even going to Hong Kong, even going to other jurisdictions outside of the EU is unlikely to help, especially if you have, for example, English law as your governing law. So what are we seeing? We're seeing a move away from European law as governing law, including English law. That is something that companies that I'm working with are considering very carefully. Certainly they're already, and they had already been doing so since, I would say, before 2014, before the invasion of Crimea, moving to seats outside the EU. And as we all know, living here in this part of the world, Singapore is seeing a major uptick in arbitrations. And I think that's a trend that will continue. Another thing that we're seeing is in a consideration very closely consideration of introducing stabilization clauses in contracts. and change of law clauses that allow you to renegotiate the contract rather than to have a change of law effectively be a force majeure or something.
So just pausing there, not everyone may be familiar with the stabilisation clause.
Yeah.
How does that work?
So a stabilisation clause, typically, what it does, it basically says that if there is a change of law, or anything else that you want to define as it, but typically it's a change of law in a certain jurisdiction, you are then able to renegotiate the contract. And then if that fails and you're unable to, in good faith, renegotiate it, then you usually typically have an arbitration clause to resolve that inability to renegotiate. But stabilization clauses were historically used in energy contracts, in particular in the Stans and also previously in Libya and stuff. It sort of dates to the 60s and the 70s. And it was something that was seen as what we would use in energy contracts outside of the Western world. And we're now looking at introducing it in the Western world. And in fact, we, even before the invasion of Ukraine, we saw them particularly being introduced due to energy transition issues. So the renewables, as you all know, the saga of the Spanish cases, which also played out in the Australian courts, the enforcement of the arbitral awards against Spain for the feed-in tariff changes regulation. That triggered, in response, particularly due to the Spanish failure to actually comply with the awards, to consider for energy companies to start thinking, okay, what do we do to avoid these situations where we can't even enforce an arbitral award? And stabilization clauses, we started inserting those in anything to do with renewables, hydrogen, and now potentially I'm doing some projects in nuclear. We're looking at how to bulletproof those, because those are obviously far more capital intensive than a renewables contract. So anything going wrong with that, particularly with changes in the regulatory environment. And as we know, with respect to geopolitics, the Trump administration is very much using nuclear as gas as part of its, well, it's sort of demands of a feudal payment. If we're sort of in Europe, we are required to take 750 billion worth of gas from America, and now we are required to use their technology to bring nuclear. And so these are things that obviously energy companies that are having to enter into private contracts relating to what is now very geopolitically fraught contracts needs to figure out a way to protect their interests. So stabilization clauses, governing law clauses, seat of arbitration, the things that you're going to talk about, alternatives, resolutions of disputes or pre-contractual even things. These are things that are now very much being considered.
So maybe I got this right, sort of broadly, they're the tools you might use on a go-forward basis, or maybe for the last couple of years going forward.
Yeah.
But the more historical contracts, the issues with sanctions, the fact that you need to have a number of people at the table, and you've got a limited number of people in the arbitration. How companies, I mean, the general counsel know that you're dealing with, and they're throwing their arms up in the air in frustration? Or?
Yeah, well, we've just had the 19th sanction package being introduced in Europe last week, or the final draft of that document, and that effectively is sanctioning all gas importation. And we also have a regulation that, so the sanction package came in October. What was adopted last week was the phase out. In the combination of those two, effectively, both long-term and short-term contracts, which companies like Total have entered into, which they assumed they were going to be able to simply renegotiate so as to have delivery outside of the EU. Well, that's now, because of the sanctions, not the possible way to deal with it. So they're seriously scrambling as to how to deal with this. The European Commission has simply said to them, oh, you'll just invoke force majeure and it'll all be hunky-dory. But obviously we all know as lawyers that that's not really how it works. And the reality is that the Russian government has introduced a provision in their Administrative Procedural Code, 248 is the article, which effectively, with respect to any dispute with a sanctioned party, they're able to go to the Russian courts as an alternative. And they've now we have had both in Hong Kong and in the UK a specific case which obviously also relates to an energy contract, the construction of an LNG facility, which has played out all the way different anti-suit injunctions on both sides in Hong Kong and in the UK, trying to stop the court hearing in Russia. And in the end, having fought hard to get these anti-suit injunctions, including UniCredit all the way to the Supreme Court in England last year, it then went back to the Supreme Court this year and said, we desperately need you to revoke the anti-suit injunction because we are now facing a fine in Russia, which we can't afford to pay. And so we would ask you to remove the anti-suit injunctions because the fine is 250 million. We have assets there, so we don't want it anymore. And they're now proceeding to go and resolve the disputes in the Russian courts. So basically we're seeing, as I said at the beginning, arbitration is clearly now weaponized, both in terms of entirely in terms of geopolitics. And so it's very difficult for energy companies to see arbitration now as a solution to the problems that they're facing. So this is, we are now, and so one way is having the seat elsewhere, but ultimately, since you can't enforce, I think the solutions that you're going to talk about are probably the more realistic ones.
Maybe we should get to Tim.
Yes.
Well, I think Anna's going to be far more interesting than what I've got to say.
Well, no, but I think when we were talking before, you were talking a lot about what you are working on with some of the leading energy companies.
Yeah. Well, let me just say this. I mean, there absolutely is a place for the process of whether you're going to go to court or an arbitration. So I'm not dismissive of that at all. But I do come from a perspective where I currently still advise boards, and I was in-house for 12 years or so. So, and it probably shouldn't come as a surprise to everyone, given their experience on this call, that, in the C-suite, arbitration courts, they hate it. They loathe it, right? So if you can find another solution, even if you take a discount for certainty, they will grab it. So in the discussions, and whether it's in the Middle East or I was in China earlier this year, and talking to very senior people in ASX companies, and I'll give you one little anecdote. What one said to me was, the problem with we have these major problems. There's lots of different parties. If you're doing a mine in Africa or South America or an energy project, I mean, whenever the JV was established, there was a different royalty regime probably in place with the local government. I mean, there will be federal, state, all the levels of government. The cost base was very different. The share register would have been probably very different. So you're seeing significant shifts in share registers. The offtake arrangements, both in terms of pricing and volume, have maybe changed, and maybe not in your advantage. Or maybe the price is just not where you thought it would be now. And so trying to renegotiate that. And this company said to me, the problem is we get people around the table, and we sort of say, thanks very much for coming along and helping. Thanks, Stephen. Thanks, Anna. And I've got a hat on, and whether it's a BHP or a Shell or a BP hat. And the problem is, everyone says, well, you're part of the problem. I mean, we're just here. And what they said was, we really should be using more independent chairs to facilitate the discussion. Now, it's a commercial discussion, so we're not lawyering up at this point. So we haven't got mediations, we haven't done submissions. This is all the tools that are available to a company to try and resolve it. So in a temporal sense, it precedes the mediation. Now, it's not exclusive, you can always have it later on. And true, some people would say, well, that's really just nothing more than a fancy negotiation. And yes, it is. But the concept is an independent facilitator. So I was in London in September, and CEDA chaired a session for corporates to attend to get feedback as to whether they would find this of utility. And it was interesting. So some major corporations there, they all said absolutely, from boardroom disputes to employment disputes to the investment disputes, this had application. And the benefit for CEDA looking at it was potentially CEDA is the appointing body of an independent. But the lesson, I think, coming back to the corporates, and again, when I recounted those stories in China at the GAR live event to some of the institutions there, because of their outgoing the Belt and Road Initiative, the investments they have, for them, the concept of finding a more sophisticated dialogue was culturally just so much more appealing than going there. So it's sort of playing in, and you're seeing it sort of happening also from colleagues, in terms of the investor state disputes, people realising, it's going to take me years to enforce. I might have an award, but good luck enforcing it. And we're seeing issues just recently in Mali, where proceedings were filed with ICC proceedings there, and then settled within a matter of probably 6 or 8 months. But again, through resolution outside of the arbitration process. I think the message I would probably want to convey is that I think in the suite of dispute resolution that as practitioners and as former judges, you look at all the processes for because you're looking at your duties to the client to try and see what you can do. I use facilitation agreements, which are modeled really on a mediation agreement, but a facilitation agreement. But the key to it is to bring in the people that you need. But so that was one aspect. I think just one other comment, just slightly differently. Investment in countries. If you're investing in countries, de-risking projects becomes really important. So the steps you were doing. What I've also seen, so if you talk to the miners, they will say the most important thing that we focus on is the quality of your asset. So tick. But the next thing is sovereign risk, and it's very interesting that in Bahrain is in the process of or has just about to move its commercial appellate cases will be heard in Singapore. And I'm told that there's another country that's about to do the same. And if you put that proposition to senior executives in mining companies, again, it's a plus because it's like the steps you're talking about, a de-risking.
Singapore was until recently, even by energy companies, not seen as a really obscene, particularly not for energy companies based in Europe. But now they are seeing it very much within that view that you've just explained. And it's interesting that also states that you mentioned are considering using Singapore. So Singapore is sort of taking off in that respect. And also in terms of ICC filings compared to Singapore, the SEAC filings and so on, in terms of numbers of cases, the ones are falling and the other ones are rising. So we're seeing this play out quite quickly now, really, given the changes. And I think that generally, energy companies, in terms of the like, let's say gas contracts and energy companies that have won arbitrations against Russian companies or lost, they're now having to find a way forward, because at some point in time, presumably things will settle and they will each have arbitrations that they'll need to figure out a way to settle an overall deal going forward. And so everybody's talking about how do we do that and who will be the facilitators.
So the other, I mean, you're going to have energy companies, mining companies. Obviously, when things go really bad, and of course you've got an insolvency event. So it's interesting when you talk to some of the leading practitioners in this country, particularly where bondholders are involved, and you've got a number of different parties, and the bondholders are sort of US based. Again, the concept of getting people around the table early on, from the various classes of creditors. We saw this in Bell, but just generally speaking. So the concepts and looking to see how as practitioners we can actually work and explore different avenues. I mentioned boardroom disputes facilitation. I mean, no company wants to have its boardroom fights in Stephen's old court, right? I mean, like, it just doesn't go down well. And mind you, you'll probably see this one proceedings filed last week by a former CEO of one of the big banks, but even in the insolvency event. So this concept, I think, of how we look at things slightly differently, I think, is quite a good and interesting and opportune initiative that CEDA, I suspect, will take forward further. They're talking about doing another session, which I described in London in February.
Do people sort of worry about the quality of the law that's being applied in arbitration awards now that you have arbitrators who feel they can depart from or give very patchy reasons, and courts look at enforcing or recognising awards simply, are all the procedural boxes ticked? The challenges can't be to the quality of the reasoning in general.
Yeah.
And the problem is, are you going to have a quality of reasoning from the arbitral system, particularly when you've got multiple challenges to arbitrators, new people being substituted and finally getting a compromise type of award? Does that affect the willingness to look at arbitration as a dispute resolution mechanism?
I mean, certainly my experience with energy companies, and especially what you said at the start, I mean, they never liked arbitration in the first place. Now these issues on quality but also independence, with this nature of many of the disputes, particularly triggered by sanctions and other things, given that they're themselves highly they're subject to a lot of geopolitical issues, but they're now also being ideologized. So you also have issues about who are the arbitrators that can actually independently and neutrally decide these disputes. And that's an issue that is now increasingly being raised, particularly to challenge Western, people from the Western world as sufficiently neutral to be able to be arbitrators. So these are serious issues. I mean, one of the examples that I recently had was an expert determination in a price review, which went terribly wrong. Talking about quality, the expert determiner felt free to sort of look up on Google and put in references to prices that he thought were more appropriate than the ones that were made and the submissions of the parties, and he wrote it in his decision. He didn't even put it to the parties. So we are now challenging that expert determination, which otherwise was on very narrow grounds on the basis of lack of due process.
Yeah.
But you're then in a desperately difficult situation since the grounds for challenge are even more limited. So a whole load of solutions in a way that a lot of people in price review arbitration would be overcome by expert determinations have now come to bite the industry. So we have to be careful.
Are there any questions for our audience?
It sounds also that there may potentially be an issue with independence of the decision makers, and whether in your example, Anna, whether that was done deliberately, potentially, if it was to just cause frustration and delay so that there is no resolution to this dispute.
Yeah, I can't comment on that specifically because I was brought in to find ways to challenge the decision as opposed to so I don't know how it played out in the first place, but it was an example also where, I mean, we're here under the guise of the ICC, but it's the ICC who appointed the external determinant, and that in itself was an issue in terms of quality that the clients are now raising. So, there's a lot of things that the institutions can do to deal with the quality and independence, but also the community ourselves will need to figure out a way forward also. I mean, there's a whole load of discussions on codes of conduct, a whole load of other things that are trying to be introduced. But yeah, arbitration is certainly being targeted as a mechanism also in the European Union. There's attempts to try to remove it, and not just in investment treaty arbitrations intra-EU. We're now moving to extra-EU arbitrations being challenged. And I would say arguably also commercial arbitration. So, there's a whole load of things that we in the arbitration community think about. But in my view, ultimately, if you have to be in a situation where you need a piece of paper in order to win as an energy or a mining company, then arbitration is the only thing we've got. I mean, Joe and I wrote an article on why Australia should sign up to the Singapore Mediation Convention, but there are still reasons why arbitration is still a better route.
Yeah, culturally, in some jurisdictions, it is absolutely. If you go to the Middle East, it's a lot more accepted arbitration there than mediation. So I think
well, I think we've probably come to time. Can I thank on behalf of the audience, Tim and Anna, for a very stimulating and fascinating sort of discussion. And our next series of conversations will start early next year. Thank you all for joining us, and hope you all have a good festive season. Happy 2026. It's been a pretty traumatic week here in Sydney, but we'll see you hopefully next year.
thanks, Steve.
Thanks.
Thank you.
Thank you very much.
Thanks, Jackie.
Thank you,
Thanks.
Joe, for hosting here today too.
No, thank you very much for the session.
Thank you.
Thank you.